Today on Bench Briefs, we're looking at a significant Supreme Court of Canada decision that revisits the delicate balance between police powers and individual rights under the Charter. In RV Vrbanic, the court tackled the question of when a warrantless search crosses the line into unconstitutional territory and what happens to evidence gathered in such circumstances. The case centers on Mr. Vrbanic, who faced multiple charges linked to evidence obtained during a police search of his home. What makes this case particularly compelling is that the search was conducted without a warrant, raising serious questions about whether his rights under Section 8 of the Canadian Charter of Rights and Freedoms were violated. Section 8 protects Canadians from unreasonable search and seizure, and it's a cornerstone of privacy rights in our legal system. Here's what happened. Police officers entered Vrbanick's residence without first obtaining a warrant. During this search, they found evidence that was then used to support the charges against him. Vrbanic challenged this, arguing that the search was not only unlawful, but that the evidence obtained should be excluded because it was the product of a rights violation. The case wound its way through the courts, with lower courts offering differing views on whether the search was reasonable and whether the evidence should be admitted. Ultimately, the Supreme Court had to weigh in on these critical issues. At the heart of the case were three key questions. First, did the warrantless search violate Vrbanick's protection against unreasonable search and seizure under Section 8 of the Charter? Second, assuming a violation occurred, should the evidence gathered during that search be excluded under Section 24(2) of the Charter? This section allows courts to exclude evidence if admitting it would bring the administration of justice into disrepute. And third, the court needed to clarify the legal test for determining when a warrantless search can be considered reasonable in the context of this case. Why does this matter? The use of warrantless searches by police is a contentious issue. On one hand, the police need tools to investigate crime effectively. On the other, Canadians have a constitutional right to privacy in their homes. The Supreme Court's ruling in Vrbanic helps define the limits of police authority and provides guidance on how courts should handle evidence obtained without a warrant. It's a reminder that the Charter is not just a theoretical document. It has real teeth when it comes to protecting our rights. The court's decision reinforces that warrantless searches are presumptively unreasonable unless specific exceptions apply. These exceptions might include urgent circumstances where obtaining a warrant is impractical, or situations where consent is freely given. But absent such circumstances, the police must get a warrant to respect the privacy rights guaranteed by Section 8. Moreover, the decision clarifies the approach to Section 24(2). When evidence is obtained through a charter breach, courts must consider factors like the seriousness of the violation, the impact on the accused's rights, and society's interest in adjudicating cases on their merits. The goal is to maintain public confidence in the justice system by excluding evidence that would compromise the integrity of judicial proceedings. RV Vrbanic thus marks an important reaffirmation of constitutional protections against unreasonable searches. It sets a clear standard for police conduct and provides a roadmap for courts when dealing with evidence from warrantless searches. For anyone interested in criminal law, civil liberties, or the ongoing dialogue between security and privacy, this case is a must-know. Thanks for listening to Bench Briefs. Be sure to join us next time for another deep dive into a landmark Canadian legal decision. Until then, take care.